There are personal injury cases that involve car accidents, slip and falls, medical malpractice. And then there are cases that make you stop, reread the facts, and ask yourself how this even ended up in a courtroom. This is one of those cases. This might actually be one of the strangest and most fascinating product liability scenarios I've ever come across, because it forces us to confront a question the law deals with all the time. Does something being unusual automatically make it unforeseeable? Here's what happened. A client purchases a product that is advertised as 100% silicone. No metal, no internal components, just silicone. According to the marketing, it's completely non-metallic and therefore safe around medical imaging equipment. At some point later, this person goes in for an MRI. Now, for anyone who doesn't know, MRI machines are not like X-rays or CT scanners. An MRI uses extremely powerful magnetic fields. Anything metallic inside or on the body can become a projectile in a fraction of a second. And, unfortunately, this client learns that the hard way, because despite the product being marketed as 100% silicone, it turns out it contains a metallic core. When the MRI starts, the object accelerates violently. According to internal descriptions, it behaves like a railgun. In plain terms, it is yanked by the magnet with tremendous force, causing catastrophic internal injuries. It's horrifying, it's shocking, and yes, it's uncomfortable to talk about, but legally, it raises very serious questions. The first reaction most people have is to laugh or immediately judge the situation. And if this case went to trial, that reaction would absolutely be present in the jury room. Jurors would likely ask, why would someone wear that to an MRI? They debate personal responsibility. They question common sense. But here's the critical legal point. Making a choice that others wouldn't make does not automatically equal negligence. Negligence requires more than an unusual decision. It requires a failure to exercise reasonable care. And if this person genuinely believed, based on the manufacturer's representations, that the product was entirely silicone, then from their perspective, there was no risk, which shifts the focus to the manufacturer. Product liability law doesn't ask whether a company intended to hurt someone. It asks whether the product was defective or misrepresented, and whether the injury that occurred was foreseeable. And foreseeability is the heart of this case. The defense would likely argue that it is not foreseeable for someone to wear this product during an MRI, that it's an edge case, an outlier, something outside the normal course of use. But plaintiffs would counter with a very compelling argument. If you sell a product intended to be worn internally for extended periods, and you advertise it as non-metallic, it is entirely foreseeable that someone might wear it during daily activities, including medical appointments. People forget things. People trust product labels. People rely on representations made by manufacturers. And MRI safety is not some obscure risk. Hospitals warn patients about metal constantly. The danger of metallic objects in MR is as well known, which brings us to the real-world precedent that makes this scenario even more unsettling. In 2016, in the United Kingdom, a documented medical incident occurred involving a patient undergoing an MRI scan within the NHS healthcare system. The case was later discussed in medical safety literature and radiology incident reports. The patient had an internal device believed to be non-metallic. During the MRI, the magnetic field caused sudden movement, resulting in serious internal injury and emergency intervention. The takeaway from that case was not mockery or judgment. It was a reassessment of device labeling, patient screening procedures, and manufacturer disclosures. Medical journals emphasize that hidden metallic components, even in consumer products, pose a real and foreseeable risk in MRI environments. In other words, this isn't hypothetical. This isn't science fiction. This has happened, which strengthens the argument that a manufacturer falsely advertising a product as 100% silicone could absolutely be held accountable. Because foreseeability doesn't mean predicting the exact moment, person, or circumstance. It means being able to imagine, in the normal course of human behavior, that harm could occur. And if a company knows its product might end up inside someone's body and knows MRI machines exist, then mislabeling that product crosses a serious legal line. Would a jury struggle with the facts? Absolutely. Would there be uncomfortable conversations and deliberations? Without question. But the law is not about moral judgment or personal taste. It's about responsibility. And in this case, if the facts are true, responsibility may rest squarely with the company that misrepresented what it sold. This case is uncomfortable. It's strange. It's unforgettable. But it is also a powerful reminder that product liability law exists for a reason. Because trust in labeling, materials, and safety claims is not optional. It's essential. And when that trust is broken, even in the most unexpected ways, the consequences can be severe.